From the original proposal of 27.352 billion, the amount is raised to 40.107 billion. Madam Speaker, the BICAM adjustment of 12.75 billion will correspondingly increase the total expenditure program from 6.352 to 6.365 billion. Supposedly, meron tayong PowerPoint presentation. Wala. Based on my scrutiny, dahil wala tayong PowerPoint presentation, papakita ko lang at sasabihin ko na lang, babasahin ko na lang isa-isa. Based on my scrutiny, the BICAM made the following adjustments on the SAGF of the affected agencies. 1. ACF, Agricultural Competitive Enhancement Fund, dinagdagan ng 274 billion. Remedies Fund, ACF dinagdagan ng 274 million. Remedies Fund dinagdagan ng 28 million. Competitiveness Enhancement Measures Fund dinagdagan ng 1 billion. Fisheries Management Fund dinagdagan ng 13 million. Rewards and Incentives Fund dinagdagan ng 3.6 billion. Spectrum User Charge dinagdagan ng 5 billion. Fire Code Income dinagdagan ng 2.5 billion. Land Registration Fees and Collection dinagdagan ng 37 million. Other executive offices of the Dangerous Drugs Board dinagdagan ng 20.95 million. National Endowment for Culture and the Arts, dinagdagan ng 75 million. Philippine Space Agency, dinagdagan ng 126 million. Yung Coconut Development Fund and Coconut Consumer Stabilization Fund, dinagdagan ng 65 million. Total increase of 12,754,670,000 sa automatic approval. What are the legal and constitutional violations demanding immediate resolution? Madam Speaker, the following critical constitutional questions must be urgently addressed as they strike at the very heart of our democratic budgetary process and threaten the integrity of future national appropriations. First, constitutional infirmity. Has the Bicameral Conference Committee, by unilaterally increasing SAGF by 12.7 billion, rendered the entire 2025 expenditure program constitutionally defective? This unprecedented manipulation raises the specter of a fundamentally flawed budget that violates Article 6, Section 25, Paragraph 1 of the Constitution, which explicitly prohibits Congress from increasing the appropriations submitted by the President. Second, fundamental breach. The core constitutional question that demands immediate clarity. Does Congress, through the BICAM, possess any legal authority whatsoever to inflate SAGF amounts, special accounts in the general fund amounts, beyond the actual program expenditure supported by their earmarked sources or earmarked revenues? This appears to be a direct violation of the established principles that special accounts in the general fund are by their very nature limited to their earmarked revenues and cannot be arbitrarily expanded beyond their statutory limitations. These are not mere technicalities. They are fundamental breaches of our constitutional architecture that could render the entire budget process null and void. The gravity of these violations cannot be overstated, as they threaten to establish a dangerous precedent where future Congresses might feel emboldened to disregard constitutional constraint with impunity. Mr. Speaker, as I mentioned earlier, Madam Speaker pala, as I mentioned earlier, the other category of the earmarked revenues is the use of income in the general fund. which by virtue of statutes or enabling laws authorizes agencies to use part of their income, the general fund, for a specific program or project which generally included in the program portion of the GAA. I want to bring to your attention that the BICAM amended the line item appropriation of the DPWH of the Special Road Fund, adjusting the net figure of 16.756 billion to 34.74 billion, or an increase of 17.992 billion. However, the amount in the special provisions is maintained at 16.75 billion. Hindi balanse. Pero in-increase yung line item appropriation in the DPWH or the Special Road Fund. The Special Road Fund is constituted from amounts collected by virtue of Republic Act 8794 as amended by Republic Act 11239, abolishing the Road Board and providing for the disposition of the motor vehicles user charge, which shall be automatically credited to a special account in the General Fund of the National Treasury, constituted as a Special Road Fund, and shall be earmarked for the construction, upgrading, repair, and rehabilitation of roads and bridges, road drainage to be included in the Annual General Appropriations Act. It is explicit that Republic Act 11239, it is explicit that all monies collected under this act shall be remitted to the National Treasury under a special account in the General Fund, credited to the amount to the Special Road Fund. For 2025, the proposed revenue from the motor vehicles user charge tax collections, only the amount of 16.75 billion is programmed for expenditure in the 2025 National Expenditure Program. The BICAM added 17.992 billion to the 16 billion which was originally proposed in the NEP. But here's the problem. The 17.992 billion was not sourced from the available balance of the Special Road Fund, but from pooled sources of funds or cuts on realignments from other agencies. Pwede ba yun? Mr. Speaker, Madam Speaker, although the increase of 7.992 billion to the line item appropriation of the DPWH Special Road Fund will not increase the total expenditure program of the government, is it proper or legal to increase the Special Road Fund from funds coming from other sources in the GAA and not from earmarked revenues coming from the motor vehicles user charge? What are the legal and constitutional questions raised? The increase of 17.992 billion on the line item appropriations of the DPWH Special Road Fund was that sourced from the specific earmarked revenues stipulated by law or Republic Act 11239, which must come from the MVUC, but allegedly sourced from pooled or reallocated sources from other agencies. The main legal and procedural concern is whether Congress, through the BICAM, can increase the amounts in the Special Road Fund beyond what is supported of program for expenditure from the earmarked revenues, and whether such increase sourced from other fund sources violate the enabling laws and constitutional budget process. The main issue here is, can the Special Road Fund be augmented from other sources of appropriations in the GAA? It is explicit in the law that the source of funds for the Special Road Fund shall come from the MVUC tax collection, which shall be remitted to the Bureau of Treasury under a special account in the General Fund appropriated in the GAA. Is it right to assume that if the increases are not supported by actual collections from the designated revenue sources, or if they are, or if they alter the nature of the appropriations set by law, these adjustments may be legally questionable and vulnerable to constitutional challenge. Mr. Speaker, I was expecting that these congressional insertions in the SEGF will somehow be subjected to presidential veto because it bloated the expenditure program submitted by the President. Yes, I am aware that preconditions were included in the implementation of the special provision by subjecting it to judicious programming based on the actual collections and utilization of funds. But my point is, by increasing the amount in the special provisions of the SAGF, there is a corresponding increase in the expenditure program submitted by the President, which may breach the constitutional limitation in the appropriation of funds. Of the numerous provisions on SAGF amended by Congress, only the special provisions of the Bureau of Customs on rewards and incentives was conditionally vetoed. On the other hand, the special road fund, which has substantially increased from 16.756 billion to 34.748 billion, was merely noted by the President under the general observations portion of the veto message. If you can remember, the direct veto was only 26 billion for the DPWH and 168 billion in unprogrammed funds. Madam Speaker, I must now address a final matter that, while not technically classified under automatic appropriations, involve similarly protected earmark funds, vital to our universal healthcare system. The syntax law explicitly mandates that portions of revenues from tobacco and sugar-sweetened beverages be earmarked for PhilHealth to fund healthcare services under Universal Healthcare Act. While these funds may not be formally designated as special accounts in the general fund, like this previously discussed, the law is very clear in requiring that earmarking for PhilHealth. These earmarked funds, by their very nature, must be used exclusively for their statutorily designated purpose, healthcare delivery for the Filipino people. Similar to the national tax allotment, this fund should be automatically and regularly included in the annual General Appropriations Act. However, in the 2025 budget, PhilHealth received zero allocation from these mandated earmarked funds. This zero allocation represents a clear failure to comply with both the syntax law and the Universal Healthcare Act. Congress has not provided what is legally due to the Filipinos. Again, Congress has not legally provided what is legally due to the Filipino people under these laws. It is particularly troubling that even a token 1 peso budget would have saved PhilHealth's legal standing for augmentation purposes. Instead, the complete absence of allocation effectively prevents any possibility of funding restoration. Madam Speaker, this zero allocation for PhilHealth represents a serious departure from the state's obligation to fulfill the promise of universal health care for all Filipinos. This omission demands immediate rectification to honor our legal commitments and our moral duty to provide healthcare access to our citizens. The failure to allocate mandated earmark funds to PhilHealth raises profound constitutional questions that merit careful examination. The 1987 Constitution explicitly enshrines health as a fundamental right. Article 2, Section 15 declares that the state shall protect and promote the right to health of the people. while Article 13, Section 11 mandates that the state shall adopt an integrated and comprehensive approach to health development, which shall endeavor to make essential goods, health, and other social services available to the people at affordable cost. By withholding the statutorily mandated earmark funds from PhilHealth, the government failed to fulfill its constitutional obligation to provide the health benefits guaranteed under the Republic Act 11223 or the Universal Healthcare Act. This law was specifically enacted to ensure that all Filipinos are guaranteed equitable access to quality and affordable health care, goods, and services, and protected against financial risk. Pending judicial review, these constitutional concerns are not merely academic. Multiple petitions have been filed before the Supreme Court, challenging both the zero budget allocation for PhilHealth and the related transfer for PhilHealth reserve funds. The resolution of these cases will have far-reaching implications for the implementation of the universal healthcare and the protection of Filipinos' constitutional right to health. Mr. Speaker, Madam Speaker, Mr. Speaker, yes, Mr. Speaker, as we await the Supreme Court's guidance on this critical matter, we must recognize that the stakes could not be higher. The health, the well-being of every Filipino. Mr. Speaker, my dear colleagues, my dear Filipino countrymen watching this on live coverage, I rise today with a resolute heart to speak on our national budget, not as a ledger of pesos and centavos, but as a living promise we make to every Filipino who trusts government will safeguard their health, their dignity, and their hope. The numbers we debate are in truth the measure of our compassion, our dignity, our will, and the test of our constitutional duty. These items under the automatic appropriations, particularly the special accounts in the general fund and the use of income in the general fund, is a product of painstaking legislations passed in previous Congresses, fully debated by our illustrious predecessors in the four corners of this legislative hall. The BICAM has practically altered and superseded 13 Republic Acts or special laws, and to include the PhilHealth funds reduction, a total of 14 laws that earmark certain funds from sources already specified as a product of exhaustive debates in both the House and the Senate. The 14 special laws specified under the automatic appropriations, particularly special accounts in the general funds and the utilization of income under the general fund that were altered and superseded